the attitude that we even see here is let's get a conviction at all costs. We just need a conviction. We just need to send somebody down. And ultimately what happens with that mindset is we aren't looking for the truth. We should look at this as state violence, the same violence that people experience on the street, for example, that everybody is rightly angry about and wants the state to respond to. This is the same thing. It's violence in another form. If you're sending somebody to prison for 20, 30 years for something they didn't do, that is violence.
Do you know that in Jamaica today, if you are accused of a serious crime like murder, you could be found guilty, even if all the members of the jury don't agree? Even if as many as 2 out of 7 jurors are convinced that you are innocent, you can still be found guilty and sent to prison for the rest of your life. That wasn't always the case in Jamaica. That development has happened fairly recently. Jamaica copied the idea of non-unanimous jury verdicts from other countries. The US had it and the UK had it. And I guess the argument could have been made that we're doing it for efficiency. But I don't know if when we copied it, we understood the roots of where that system came from or appreciated the effect it could have in leading to wrongful convictions. But our guest today on Stuck is able to talk to us about both those things.
My name is Nisha Waller, more recently Dr. Nisha Waller, as I recently completed my PhD.
She's a racial justice lead at the UK legal charity Appeal, and she's the co-author of Doubt Dismissed, a document which exposes the hidden history of non-unanimous or majority verdicts. There's no controversy in saying that non-unanimous jury verdicts were created in the US because of racism. And Dr. Waller's research has looked at its origin in the UK. Her research has also linked majority verdicts to more than 56 wrongful convictions in the UK. She's a brilliant legal researcher with a PhD from Oxford, but the real reason she's a big deal is that she has Jamaican roots, and she's passionate about seeing justice in Jamaica and for Jamaicans. This is my conversation with Dr. Nisha Waller. Perhaps we could start today by talking about your why. You have looked at majority verdicts and the jury system. It's a very unique area. What is it that drew you to this area of study and research and the topic of wrongful convictions in general?
Okay, the topic of wrongful convictions in general, I think my interest in issues of crime and the criminal legal system actually first began all the way back in school when I did a sociology module on crime and deviance, as they called it. I also think growing up in a home with one black and one white parent, I was quite attuned to how different people are treated in Britain, depending on their background, and that awareness of racism and inequality, which is very prevalent in the British criminal legal system, has always very much stayed with me. Then, while studying criminology at university undergrad, somebody close to me was convicted under a controversial English law known as joint enterprise, which is also used in Jamaica because there was a significant case of Ruddock, which was heard in 2016. So yeah, it's not just used in England. And it's a controversial law because it allows multiple people to be convicted of the same offence, even if they didn't directly contribute to the conduct of the offence itself. And just being present at the scene has actually led to people being convicted. All the jury has to do is decide that presence was supportive or intended to be supportive in some way to the person who carried out the crime. And in this country, black people are 16 times more likely than white people to be convicted under this law. And that was really the sort of, I guess, the issue that was at the core of why I'm continuing to work on wrongful conviction cases and research around that. And that led me to Oxford doing my master's and my PhD. I noticed that this charity that I now work at called Appeal had a job application out to look at a really specific piece of work, which was this research on majority verdicts. And I was really curious because I'd also never really thought much about majority verdicts at all. The charity, though, was inspired by US innocence projects, and that's where the interest of the charity in race and juries was really came from, because there was lots of work that had been done on this in the US. It's also, the jury is typically in this country seen as the only part of the system that almost isn't racist and works, but actually nobody's really dug deep into whether it is functioning correctly or not, because we have really strict rules on jury secrecy here. So you can't go and interview a juror from a real case, for example. So we don't actually know that much about the jury system. And so I applied for that job and now have stayed at this charity doing other bits of work. But we continue to, be really concerned about the move in this country, or the suggestion that we might move towards less jury trials and give more power to judges, which is a concern for us, yeah.
Okay. So on that, we are directly connected. I read the appeals response to the Levinson review, but I'm getting ahead of myself. I want you to, could you please share just what your research is in doubt dismissed, so that we can have a sense of what is it we're talking about?
Yeah, exactly. So our research looks at why majority jury verdicts were introduced in England and Wales in 1967. And by that, I mean, a majority verdict is a non-unanimous one, so not all of the jurors agree on a verdict, for people that might not be familiar. And before that, in 1967, before that year, juries had to reach a unanimous decision. All 12 jurors had to agree. At the time, the public explanation for why they made that change was that they needed to deal with jury tampering or corruption that was alleged to be happening. But we were generally concerned about majority verdicts, particularly given that many of our clients who were wrongfully convicted had been convicted by a majority verdict, and we noticed that pattern. But it also felt to us, as a legal charity that works on wrongful conviction cases, that it inherently introduces reasonable doubt into a conviction. If one or two jurors don't agree, how is that a conviction in absence of doubt, right? It's common sense. We were also very aware that in the 1960s in Britain, it was a time when we saw Britain become far more diverse. This was when we saw a major influx of migration from the Caribbean, particularly Jamaica, known as frequently called the Windrush generation, which my grandparents were part of. What really caught our attention, or the intention of the charity, was what happened in the US in the case of Ramos, which ultimately abolished majority verdicts in the two states that they were allowed in the US. And that research demonstrated that after slavery, and when Black people got the right to sit on a jury, majority verdicts were introduced deliberately to silence their voices. And the US research also showed that there was a link between miscarriage of justice and majority verdicts. And they also were able to demonstrate that majority verdicts were more common in cases with Black defendants. And so that made us think, what if the same racial dynamics exist here? No one's ever looked into this. So we went into the archives for months, the National Archives in London, and what we found wasn't too dissimilar. Obviously not exactly the same, because it took place some time after the US, so things were not as explicitly racist in terms of language. But official documents and parliamentary debates revealed that the change to majority verdicts was partly the result of, or driven by, fears that immigration was increasing and the makeup of the British population was changing in terms of race and class in particular. And in particular, there were concerns that Caribbean and working class jurors were diluting the sort of caliber of the jury. And one MP, I think, even said, the Englishman is now going to be tried by a common clay. That was his language. I also remember a quote that stood out to me, which was about a West Indian bus conductor. I think it might have been some form of commentator that gave evidence to a commission at the time, who said, a West Indian bus conductor would be wasting their time on a complex case, as if to say they don't have the intelligence to deal with it. So there was explicit racism here. However, the Home Secretary at the time, Roy Jenkins, didn't ever explicitly say, I'm going to introduce majority verdicts because I want to dilute the voices of, Black and other racialized minority people. He used the preface of nobbling. This was the issue of jury tampering, which he referred to as nobbling at the time. But ultimately, what the research illustrated to us was that while majority verdicts are really often just presented as like a taken for granted, neutral, legal piece of reform, the truth is that they were introduced during a time of anxiety about a changing Britain, and they've quietly sort of made it easier to convict people. And nobody really knew the underpinnings of it. And so that's what we first brought to light through our research.
I think that point about it introducing doubt is worth considering, because take Jamaica, for example, and it's a number of things that we have to come to, because not only did we go from unanimous verdicts to majority verdict, but we've also shrunk the size of the jury from 12 to 7, even in the case of non-capital murder, right? And so now, if I'm correct, and I'm correct, I didn't check this morning, but majority verdicts are even accepted for a jury of 7. So you've gone from 12 people having to say, we agree, to 5 people having to say, we agree. And it's striking to me that that seems like we are now in a world with a lot less rights, but somehow we are able to accept it because 5 people agree. And so I guess the first thing I would ask is there, you have done this research, but is there a problem with 5 people agreeing and 2 people say no? Perhaps you could speak about the connection between just more about wrongful convictions and majority verdicts, because I see that your charity has identified a number of cases where you have been able to make that direct connection.
Yeah, I'm very surprised. I wasn't actually aware that Jamaica had made the decision to reduce the number of jurors. Is that, just out of curiosity, is that like a cost-saving strategy?
So, so we'll also go back to the reason for these decisions, because Jamaica, I guess we'll argue that we don't have those overt racial issues, but a bad idea is a bad idea regardless of where it comes from. And I don't necessarily agree that there's no racial issue, because there is a classist issue. But the main thrust of the government's measures in Jamaica is about efficiency and the backlog. And so there are a number of things that are put on the table that are meant to make the system more efficient. And efficiency means just clearing the backlog without equal weight, in my opinion, being given to whether or not this will result in a fair trial, and not just a fair trial, but people being wrongfully convicted.
Really interesting, because at the time when the majority verdicts were introduced here in the UK, I should say, actually, I don't even like the language of majority verdicts, because it frames it as some form of like democratic vote. The majority said this, so therefore it's more legitimate. I usually say non-unanimous or split jury decision, which some people don't like. But I think majority, that language has been intentional, right? Because when you hear majority, you're like, oh, the majority agreed.
Most of us have agreed.
Okay, right? So for me, and for us as a charity, the jury system is the best option that we have, right? Because we know from experience with judges, etc., that generally speaking, you have more of a chance of diversity of thought being put to your case in considering your case. And that I can say the same for the number of jurors, right? If you have 12 versus 5, it's likely that you'll have more diversity of thought in the case of 12 jurors. The same thing is almost happening here, where there is this pressure due to massive court backlogs. And the answer, as we kind of anticipated, was likely to be, shall we do something about juries? Shall we reduce the number of cases that are put to juries? The government's proposals in this country aren't as drastic, as in there isn't a push to completely change the number of jurors in trials overall, but there is a push to change some offences, so that there are some offences that don't require a jury trial at all, and some are heard only by judges or magistrates. But I think that juries are better placed to understand the nuance of a case, for example. I think they're less likely to just accept the police and prosecution case at face value and actually look at it critically. For example, we've seen in protest trials where juries have actually acquitted defendants who had a defence that they were charged with, I think it was violent disorder, but the jury acquitted them because their defence was that they were actually defending themselves against the police, right? It's hard to imagine a judge-alone trial reaching the same outcome. So yeah, juries have been really, really vital in ensuring that there is a sort of diversity of thought and a critical view put to cases, right? I think I've gone off topic a bit here, and I'm struggling to remember exactly what your question was.
Well, I wanted to bring you to the 56. That's the number I read in the Guardian article.
Yeah.
Yeah.
We have since identified more since we published that report. We don't have an exact number because they don't collect data on majority verdicts, which is one of our main issues, and one of the recommendations of our report was that we need better data on this to assess its impact and the extent of the relationship between majority verdicts and wrongful convictions. However, when we look to other jurisdictions, and the US does operate quite differently to us, but their research is very rigorous on this, and they have consistently found a connection between miscarriages of justice and majority verdicts, in that it is far more likely a majority verdict would lead to a wrongful conviction than a unanimous one. However, there is some research in Scotland that points to issues with unanimous verdicts in that they sort of force people into a box, even if they don't necessarily want to vote that way. And the difficulty is we don't have access to the deliberation room to really assess how these things work in real cases. So we can't say for sure if there is a clear and definitive link, only anecdotally through our caseload. But the common sense view, I think, is that there is a reason why one or two people don't agree. And we can't assume that all jurors are just, these jurors that dissent and don't agree are just silly jurors who don't understand the case. We can't assume that. We're assuming that they're all rational-minded people, otherwise they wouldn't be sat on a jury. And so we have to really think about that. We have to consider, why is it that we're willing to accept, even in cases of murder where there is a life sentence at stake, people's whole life is at stake. We are willing to accept a verdict on which two people who've heard the whole case in the same way as the others don't agree. The key issue for us as well is we don't have enough data to find out whether there is something common amongst those people, i.e. their background, their class or racial background, that makes it more likely that their votes will be the ones that are sidelined. And that is why we titled the report Doubt Dismissed, because those people who have doubt, their vote and their doubt is ultimately just dismissed to reach a verdict. And the main concern in this country is if we got rid of majority verdicts, we would, increase the court backlog, see more retrials and have to spend more money. But at the end of the day, the cost of justice is the cost of justice, right? Like, how can we, when you were talking about the case of Jamaica and how they have changed the jury system quite drastically, there needs to be consideration of both. And if anything, the priority should be ensuring that innocent people aren't going to prison, right? Yeah. So for us, there is, anecdotally, we know there is a link, but we do need more information to be able to definitively say that. And that is one of the pushbacks of our research. We have had resistance because of that. And we are currently in the process of trying to engage with the Ministry of Justice here to see if they will agree to systematically collect more data on this.
What's up? I just dropped in here to say that if you aren't already subscribed to this channel, please go ahead and do so. If you like what you hear, if there is something that you don't understand or you want us to talk some more about, please share it in the comments. All right, back to the show. All right, well, I think just being able to point out a connection is something that is important. And in Canada, researchers have raised the same concern about not having an ability to make any definitive statements about the jury because of the secrecy. And that's one question. I guess Jamaica is also a country where there is secrecy in terms of the jurors' deliberations. And what exactly are you calling for when it relates to the ability to research the thinking of the jurors? What would be a best case scenario for you as a researcher? What is it that you would want to explore? Because we are making decisions without information. That's one thing that stands out to me. So what would you want to explore to equip the government to make the best decisions?
Well, one of the recommendations of our report was to adjust the Section 8 of the Contempt of Court Act, which basically says you cannot speak to jurors in real cases. Put simply, obviously, the jury system is obviously for a reason protected by these laws. We don't want people to just be able to go and speak to jurors freely with under no controlled circumstances where they can influence jurors, for example. But even in cases where there are reports that a juror has said a problematic remark, a racist remark, for example. There's a case called Mirza in this country. A juror reported racist remarks from other jurors and the court still refused to investigate because of the jury secrecy rule. So almost accepting that discrimination and prejudicial views could have influenced their decision to convict, the courts still say, jury secrecy trumps all of that. And so that is a massive, massive problem. So that's one thing. We need the courts to be able to investigate, or another body, an independent body, ideally, to be able to investigate these allegations to assess whether they have had a substantial impact on the case and therefore whether the case needs to be reconsidered. But also, as researchers, we can't actually assess whether the jury system is functioning fairly. It's almost assumed that it is, but we can't really truly assess that without being able to speak to real jurors in real cases and carry out research with them. So what we're asking for is the ability to conduct controlled research with real jurors in real cases in order to assess the deliberation process and have more, I guess, effective and accurate policy making. Because at the moment, policy on juries is almost like a bit of guesswork, right? Because we don't actually know how they function apart from through research that uses case simulations with juries that have been put together for the purpose of research, who know they're doing this for the purpose of research. There is a couple of big studies that have been done here with jurors that would actually reflect real life juries because they were pulled from the same system that populates juries in this country, but they were given a simulation case, so didn't sit on a real case, although the case was previously heard as a real case that they recreated for them, but they were fully aware that they were not making a decision that was going to lead to a real person going to prison, right? And so that is all we have to rely on, and research from other countries that do allow research with real juries, which is like the US. They have got research with real jurors, but again, their system is very different to ours. Even in the case of majority verdicts, when they were in use there, they didn't have a minimum deliberation period, so they could just come to a verdict that was a majority decision straight away, whereas in this country, in England and Wales, the jurors have to deliberate for at least 2 hours and try to achieve a unanimous decision before the judge gives that majority direction and says, okay, we'll accept less. So yeah, ultimately, we just need to be able to there's no other institution that you'd say, let's create policy without doing investigation and research first. There's no other institution like it. And it's really bizarre because for myself as a researcher, I can, believe it or not, access prisons if I want to. I can work with the police if I want to. I can even, which is a little bit harder, but I can even do research with the judiciary. But I can't do research with jurors. It is the only institution that is completely protected by these rules, and it hinders our ability to improve the jury system and make it better.
I just realized I didn't ask you you spoke about Ramos, but perhaps could you just speak some more about it in terms of why it was significant? It was the case that led to this research, but could you just give a summary of what it was? I mean, I perhaps do that in introducing the podcast, but I just wanted you to speak more directly to it. Yeah,
I should say I'm a bit rusty on all this because I'm working on a completely different research project right now on this.
That's fine.
It's back up for a while, but Ramos ultimately was the case after many unsuccessful attempts in the US that led to the abolition of majority verdicts in the two states that they were operating in, which was Louisiana and, told you I'm rusty,
no.
Louisiana and, it's on the tip of my tongue, Louisiana and Oregon, that was it. So yeah, majority verdicts were operating in the states in Louisiana and Oregon at the time. And the Ramos case was the first successful attempt. There had been many previous attempts to do this. And it was ultimately the result of like really, really robust and detailed research, which really demonstrated it was a problem. And Ramos's conviction was quashed and he was retried under, I guess, the reformed law, which didn't allow for majority verdict, and he was acquitted as a result. So previously he was convicted under majority decision, and then when that changed, he was acquitted at the retrial. And so that didn't apply retroactively, though, in Louisiana, if I remember correctly. So all the people who were previously convicted under a majority verdict in Louisiana are still convicted, I think. And I think in Oregon, they did apply it retroactively. It's either one way or the other. They did it in one state, not the other. So one state is still fighting to kind of redress the harms that occurred through majority verdicts, and the other has made the decision to actually apply it retroactively. And so, yeah, that was really, really significant because, yeah, again, for a long time it had existed, for a long, long time, and nobody had really thought much of it, I guess, except those who did and went and looked. And so that's why I think, particularly in the society that we live in now, issues like these that are in US and the UK specifically these decisions have been informed by race and the racial demographic of the societies that these laws existed in. We have to acknowledge how racism becomes much more covert as time has gone on, and we actually do have to sort of question things and actually look for them as researchers. They're not often in our faces, and that's what's really good about, having that connection with those in the US that prompted us to do the same, because otherwise we may have never looked at it.
Is there anything else that you mentioned some other research? Is there anything else that you are working on or have worked on in relation to wrongful convictions that you think is important to share briefly, just that as we are we are beginning this conversation in Jamaica and
Yeah.
really seeking to raise awareness. I will ask you more about that, like as a person with Jamaican heritage, why you think that this type of work is important. But is there any other area apart from the jury system that you think is worth looking at?
Whole system. When you work on, I don't know what else to say, honestly, when you do this type of work and you see wrongful conviction cases firsthand and you start to unravel how we got there, it's like the whole system underpins these convictions. So for example, we had one of our clients' conviction was quashed in 2023 in the summer. Andrew Malkinson, who was convicted and sentenced to, served 17 years, which was over tariff because he wouldn't admit to his guilt. So he wasn't released when he could have been. I say admit to his guilt, but he wasn't guilty, right? So, but the prison system doesn't allow for, in the way it operates in terms of progressing through prison, doesn't allow for the concept of wrongful conviction at all, which in itself is a huge problem because it assumes that the system always gets it right, which is absurd. Of course it doesn't. No system does. But yeah, coming back to the question of like what the problems are and what needs to be looked at, it is absolutely every single stage. And obviously it begins with the investigation, but the investigation is also informed by police work that happened before that. Because when you have a suspect come in, you look at what you have already, the knowledge that the police have about them already, which isn't necessarily accurate. It's informed by police, right? Who, particularly in this country, are more likely to stop and search a young black man, many, many times more likely to be stopped and searched than a young white man. So he's likely to enter the police station if he's arrested with a whole sheet of interaction with the police that might then make the police treat him differently. For example, in cases where joint enterprise is used, which is what I'm working on currently, you could potentially be treated as a witness rather than a suspect if you were at the scene of a crime, right? But if you have a history of police contact, some of which has been hostile because the police don't always engage with you nicely, the police might be more inclined to treat you as a suspect rather than a witness. So it all begins really before the crime that you are being accused of has even occurred. It begins with the way police do their work. Then the next process is obviously the charging process. And for example, in this country, and I know it is different in Jamaica, but their recent research found that the Crown Prosecution Service who charge cases are significantly more likely to charge non-white suspects for the same comparable offences, even when factors such as previous offending has been controlled for. So at every stage in this country, there is serious issues with not only race, but also the way in which cases are prosecuted and investigated. Andrew Malkinson was a white man who'd probably describe himself as a white working class man. And there were many, many issues with the way that investigation was handled. Also, disclosure, not getting access to materials is another key issue in miscarriage of justice cases. Eyewitness testimony and identification, another huge issue in miscarriage of justice cases. So yeah, I could go on, but it's a complex issue. It really is. It's not just one thing that needs fixing to sort it out.
Yeah. I just came into this because I read a book. It's a part of just there's a book by Professor Kent Roach at the University of Toronto about wrongfully convicted, the situation in Canada. And I was skeptical, like what? Nobody is wrongfully convicted in Canada or anywhere. And when I read it, I realized that it wasn't just an alarmist thing or some hysterical thing. Like there are categories of people who are wrongfully convicted, and it's not just put on it situations, and it's not one-off, but there is a significant issue. And that made me think about Jamaica. But more importantly, as you're saying, that it really has seemed to me like the forest and the trees. Like we've been talking about the jury system, and for years as a lawyer, I've been thinking, okay, I need to respond to what they're saying about the jury system, or I need to respond to what they're saying about detention. But then wrongful convictions has seemed to just put all of it together, and I realized that here is something that this is what the justice system is about. The people who are guilty being found and held accountable, and people who are innocent and not being put in prison, and also the police not being allowed to use any tactic they use to arrest even people who may be guilty. As someone with Jamaican heritage, as you say, your grandparents are part of the Windrush generation, and someone who is working on wrongful conviction research and who's seen the importance of it in England and Wales, why do you think that it's important for us as Jamaicans to invest in this topic? Because many Jamaicans will say that the crime situation in Jamaica, how serious it is. Many people return to Jamaica from overseas having worked generations in the coal somewhere, and they come back and they lose their lives, and we are frustrated, we're tired, and there's a sense that throw the baby out with the bathwater. Why is that not a justification? Why is this work important? Is there a particular case that has really resonated with you? Is it in your research? What would you say to encourage Jamaicans to look at this despite all the reasons we may think we have as a society to not care about this right now?
I think because and this is speaking more broadly, but I think when a society responds to harm with more harm, it never solves anything. And I'm not saying don't respond to people who carry out crime and are guilty of crime and harm and violence. But the attitude that we even see here is let's get a conviction at all costs. We just need a conviction. We just need to send somebody down. And ultimately what happens with that mindset is we aren't looking for the truth. We're looking for an outcome and not necessarily the right one. And that's when we see problems arise. And it destroys people's lives, completely destroys people's lives in the same way that crime does and violence does, right? We should look at this as state violence. The same violence that people experience on the street, for example, that everybody is rightly angry about and wants the state to respond to. This is the same thing. It's violence in another form. If you're sending somebody to prison for 20, 30 years for something they didn't do, and they're going to be subject to harm and potentially violence in the place that they're going, that is violence. And I think as society, particularly here as well, we have this understanding of when we think about violence, we think about people on the street having knife fights, for example, or shootings on the street, right? We don't often think about the violence that the government and the state inflict on us as a society, as a people. And speaking particularly, thinking about being somebody of Jamaican heritage and knowing that the system that is used in Jamaica is a reflection of the fact that it being a British colony, right? We should do what we can to resist these systems when they are functioning to do more harm to our people, right? And so, yeah, I think it's that mindset of violence and harm being surface level and being the responsibility of the citizens. And as these are the only people that cause harm, when actually, if you look further up the structure, state violence is not only often the cause of the violence amongst the citizens, but it's also used to respond to that violence amongst the citizens, and will only lead to a repeated cycle if we don't address these problems.
Okay.
I hope that made sense.
Thank you. It does. I really want to thank you for taking the time to talk about this.
Thank you. It's been a pleasure, and thanks for reaching out. I was so pleasantly surprised. I was like, it was a surprise because I've never, just to have somebody from Jamaica that's really interested in the same issues and, wants to platform our work, which is privilege.
This is perhaps one of the most important conversations that we are having on Stuck. Right now, the jury in Jamaica is under fire. Tremendous fire. Over the last 15 years, governments of both parties have worked to shrink the size of the jury in Jamaica. They have removed the need for all jurors to agree on the verdict. Recently, the government raised the stipend for jurors to an all-time high, and that's commendable. But don't watch that. Government hasn't put in place the things needed to make the jury work efficiently. And while the government has made that positive step, powerful voices in Jamaica, powerful voices in Jamaican government, media, and the judiciary are calling for the full abolition of the jury in Jamaica. And the worst part about all of it? I don't think most Jamaican people know what to think about all of this, what to make of all of this. Like really, what do we know about the jury in Jamaica? What do we know about its significance, how it works, whether it's valuable, whether there is really any benefit to keeping it or not? We are told that getting rid of it will make things more efficient. How do we think about it except based on our feelings, right? So I'm working on a comprehensive video about the jury in Jamaica. And if that's something that you're looking forward to, please let me know in the comments. I'm working on it because I believe that the government is going to pick up this conversation sooner rather than later. But until then, we also have to think about more than just keeping the jury or abolishing it. We have to think about how the jury works, how it functions, what it does, and whether it's doing it effectively. Because as we have seen with how the government has dealt with the jury in Jamaica, we can keep the jury in name and yet gut it by a sort of legal gerrymandering that undermines its effectiveness. I believe, based on our conversation with Dr. Waller today, one of the most damaging changes to the jury in Jamaica has been abandoning the need for the jurors to agree on the verdict. I'm all for modeling things that are good. The jury system itself came from England. But before you take something from somewhere, you have to ask about its origins. You have to think about its effect. And you have to think about what the step will mean down the road. You know what's crazy? The UK modeled it off the US. When a man challenged it in the US and it went to the US Supreme Court, he pointed to the UK to defend it. Take it further, Jamaica modeled it off the UK. And now we see other Caribbean countries trying to abandon unanimity. And they point to Jamaica as a brave example. But it's not bravery. It's a mad rush by people who are prioritizing efficiency over fairness without striving to see how we can achieve both. Thanks for listening. Don't forget to subscribe, to like, to share, to comment. Until next time, I'm Andrew Wiles, and this is Stuck.
I've spent so much time hearing from people who will tell me I pleaded guilty because I was absolutely terrified. I couldn't go to prison. I thought I would die there. I couldn't leave my wife, my pregnant wife.
Hey, thanks for listening. Stuck is written and presented by me, Andrew Wiles. It is brought to you by The Wave on the Frequency Network. Subscribe to Stuck wherever you get your podcasts. You can read more about the project at andrewwiles.com. And if you found the conversation interesting or helpful, share it. Thanks for tuning in. Until next time.